Good afternoon, members of the panel. My name is Austin Seah, and I'll be speaking on behalf of the first appellant, Mr. Landert, on the first issue regarding GDC's quorum and a fourth issue on doping for 15 minutes. My co-counsel, Mr. Mark Maxwell Peter, will be speaking on behalf of the second appellant, Ms. Tangs. He will address issue 2 on the location of the tribunal and issue 3 on Ms. Tang's ability to participate in the qualifying games for 14 minutes. We respectfully reserve 1 minute for a rebuttal. Members of the panel, this case concerns ensuring fairness and addressing the issues of potential bias. The gold medal belongs to Mr. Landert, who earned it through his performance, leading his team's comeback in the finals of the qualifying games. However, the tribunal that reviewed the matter appeared to have a majority inclined towards Ms. Tangs. Given these circumstances, the law supports the medal's return. Failing to do so could undermine the protections and fairness that athletes are entitled to. With that, I make 2 submissions regarding the first and fourth issue. Firstly, the Games Disciplinary Committee, hereinafter the GDC, was biased in coming to a decision. Mr. Douglas and Ms. Farina are not independent and impartial arbitrators of the GDC's quorum. Secondly, the GDC had erred in finding that Mr. Landert has been liable for doping. Blue Bet is not inside the World Anti-Doping List, and Mr. Landert is hence not liable for doping. Turning to the first issue, to determine the criteria of an arbitrator, the applicable rule is Rule 33 from the CAS Code. Rule 33 states, and I quote, "Every arbitrator shall be and remain impartial and independent of the parties and shall immediately disclose any circumstances which may affect his or her independence with respect to the parties." This proposition is found in Malaysia's Arbitration Act under Section 13(8) Part B, which reads, and I quote, "In appointing an arbitrator, the director of the Asian International Arbitration Centre, or the High Court, as the case may be, shall have due regard to other considerations that are likely to secure the appointment of an independent and impartial arbitrator." As noted in both the wording of Rule 33 and Section 13(8) Part B of the Malaysian Arbitration Act, the criteria of an arbitrator requires both impartiality and independence. As long as one of these criteria are not met, this would demonstrate that an arbitrator is biased. Firstly, we argue that there was a lack of independence on both the parts of Ms. Farina and Mr. Douglas. To determine what amounts to an independent arbitrator, we can look to case law. In the 2006 CAS case of FCV and NF, at paragraph 5, the court noted that strong or negative emotional bonds through relations between the arbitrator and one party or its counsel may also indicate a lack of independence. This proposition was similarly held in the 2000 Swiss Federal Tribunal case of Sadi Senna Constructions at para 3. Turning first to Ms. Farina, there are 2 types of relationships that she has with Ms. Tangs. If I could first turn the panel's attention to para 4 of the record. She's Ms. Tang's cousin sister, showing that Ms. Farina has a familial relationship with Ms. Tangs. Essentially, Ms. Tangs is Ms. Farina's cousin, showing a personal relationship between both parties. This kind of personal connection could easily be characterized as a strong emotional bond between family members, which can indicate a lack of impartiality on the part of an arbitrator. If I could then turn the panel's attention to the very same paragraph of the record, Ms. Farina had also provided extra on-the-side coaching to Ms. Tang's team and prepared them for the upcoming qualifying games. This demonstrates a professional relationship where Ms. Farina had invested time and effort into Ms. Tang's success prior to adjudicating on a dispute involving her. With both a professional and personal relationship, it can be inferred that Ms. Farina and Ms. Tangs possess strong emotional bonds. Turning to Mr. Douglas, if I could first turn the tribunal's attention to para 26 of the record. 6 months prior to the events of the case, he was engaged to have a one-time special and personal sharing session for Ms. Tang's team. This shows professional support for Ms. Tang's team. Following the session, in the very same paragraph of their record, their relationship eventually got closer, with both parties being in contact for 6 months. This ongoing close and personal relationship constitutes a continuing positive bond extending beyond a single professional engagement. This is further bolstered by the fact that Mr. Douglas had participated with Ms. Tangs in fan meetups. Going beyond a simple role as a coach, this public association further solidifies the factual existence of a positive and strong bond that lasted for 6 months till the very date of this hearing. In fact, members of the panel, there does not need to be an actual finding of independence. Rather, it suffices that an arbitrator, based on the circumstances of the case, to be objectively viewed as such. This proposition was laid out at paragraph 7.4 in the 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency. The proposition is further supported by the IBA guidelines on conflict of interest in international arbitration at section 2b, where the relevant portion reads, and I quote, "From the point of view of a reasonable third person having knowledge of the relevant facts and circumstances would give rise to doubts as the arbitrator's impartiality or independence." In our case, we acknowledge that there is no evidence of any actual bias demonstrated by either Mr. Douglas or Ms. Farina. However, the necessary inference is that there is biasness arising from the objective reasonable third party. If I could first turn the panel's attention to paragraph 26 of the record. The GDC's quorum is a tribunal operating with 2/3 majority of its quorum maintaining documented personal, familial, and professional bonds with Ms. Tangs, the party contesting the results. They cannot objectively be viewed as independent in their adverse ruling against Mr. Landert, as seen at paragraph 33 of the record. Simply put, the presence of a familial relationship between Ms. Tangs and Ms. Farina, coupled with a close extended personal relationship between Mr. Douglas and Ms. Tangs, is sufficient for a reasonable third party to ascertain their lack of independence. In conclusion, we submit that Ms. Farina and Mr. Douglas are biased members of GDC's quorum. Now, turning to the second issue regarding Mr. Landert's doping violation. Our submissions are structured into 3 main arguments. Firstly, Rule 12 of the qualifying games should not be applied. It is overly broad and inconsistent with the WADA code, and a finding of a doping violation under the GDC's own rules is unfounded. Secondly, blue bat is not a prohibited substance under the WADA code, and liability cannot attach to unlisted substances. And lastly, the GDC's enforcement of its anti-doping rules violated the principles of legality, due process, and legitimate expectation due to the lack of clear notice. Turning to our first argument, we submit that the WADA code is the exclusive standard for doping violations. While the respondent may seek to rely on Rule 12 of the qualifying game rules to find that Mr. Landert had committed a doping violation, reliance on Rule 12 is simply wrong. Rules 7 and 13 of the qualifying game rules clearly provide that doping is defined by reference to the WADA code and the prohibited list. Rule 7 defines doping as, and I quote, "occurrence of one or more anti-doping rule violations set forth in the WADA prohibited list and the WADA code." Rule 13 instructs athletes to, and I quote, "refer to the WADA prohibited list for the list of prohibited substances." Accordingly, this shows that the WADA code forms the exclusive and mandatory benchmark for determining anti-doping violations. Secondly, we submit that Rule 12 is inconsistent and too broad. While the respondent may attempt to rely on Rule 12 for finding of liability, Rule 12 defines a prohibited substance as, and I quote, "any substance or method contrary to the spirit of the sport." This is clearly a broad definition, and crucially, the CAS has previously rejected such broad provisions. In the 2004 CAS case of Maria Louis Kelly Williams and IOC, the panel noted that a catch-all provision of other chemical substances of similar chemical nature cannot be construed to mean every stimulant, which is precisely what Rule 12 of the qualifying games seek to do. At paragraph 25 of the judgment, it was noted that such an interpretation would not pass the test of clarity and predictability. They further brought examples of other stimulants such as nicotine and caffeine, which all fall under the interpretation of Rule 12, and crucially, they are not banned by the CAS. Therefore, an extremely restrictive approach must be taken in interpreting Rule 12, which should be read together with the WADA guidelines, as it is precisely what Rule 13 has noted. Lastly, CAS jurisprudence has confirmed that sporting bodies cannot expand doping rules. In the 2011 CAS case of USOC and IOC, the IOC's attempt to impose additional sanctions beyond the WADA code was held invalid because the Olympic Charter had already made the code mandatory. Therefore, Rule 12 of the qualifying game rules should not be followed alone, and a finding of a doping violation under the qualifying game rules is incorrect and should not be followed. Turning to our second overarching argument, Blue Bet is not a prohibited substance under the WADA code. Firstly, liability only arises for listed substances, and this is constantly emphasized in multiple CAS cases, such as the 2006 CAS case of Putera and ITF, 2008 CAS case of ITF and Gasquet, and 2016 CAS case of Sharapova and ITF. Secondly, Blue Bet does not bear any similarity with any known prohibited substances. In the 2004 CAS case of Maria Louise Kelly Williams and IOC, the athlete had taken Neosaldina, which contained isomethapine. Although considered a stimulant, isomethapine was not listed in a WADA prohibited list. The panel held that an unlisted substance may only be banned if it has a similar chemical structure or pharmacological effect to a listed stimulant. Finding no such similarity, CAS ruled no violation had occurred. In our case, although Blue Bet may be considered a stimulant, it likely does not have a similar chemical structure known to any prohibited substance. If I could turn the panel's attention to para 30 of the record, Mr. Lender's medical team had researched Blue Bet, and yet they were uncertain about the product status. Presently, we do not have enough facts to determine if Blue Bet indeed bears similar chemical structures or pharmacological effects to any other listed stimulants. Notably, in Ms. Williams' case, even though isomethapine was initially considered as a stimulant, subsequent detailed medical research ordered by the courts did find that it was not considered to be a prohibited substance. Therefore, it would be presumptuous for the court to jump the gun and find that Mr. Lender had breached the WADA code without further examining the precise chemical nature of Blue Bet. Therefore, the GDC had erred in finding that Mr. Lender had committed a doping violation. Lastly, and most importantly, the GDC had violated the principles of legality and due process. The principle of legality requires that sanctions be based on clear, accessible, and foreseeable rules. Punishing conduct where regulatory guidelines are absent or ambiguous violates both due process and legitimate expectation, and this principle has been upheld in the 1995 CAS case of Quigley and UIT. In the present case, official studies on Blue Bet were yet to be concluded, and the product was absent from all official lists and bulletin. If even specialized medical professionals could not determine its legality, the GDC cannot reasonably expect the athlete himself to have known. The vague spirit of the sport clause in Rule 12 fails predictability and foreseeability tests as required by the CAS. In conclusion, with regards to Mr. Lander's issue on appeal, the GDC quorum was biased in coming to a decision, and the GDC had erred in ruling that Mr. Lander committed a doping violation. Unless I may be of further assistance to the panel, this concludes my submissions. Thank you. I will now hand over my time to my co-counsel, Mr. Mark Peter, who will address the remaining issues for 14 minutes.
Thank you, counsel.